Dalia Knipša, and I am the Youth Delegate of Latvia to the United Nations, and I will also be today's moderator of the discussion. And just a quick reminder of the structure of this event. We'll start with opening remarks and introductions, moving on to the first topic of our discussion today regarding the making the ILC more understandable, moving on to climate change, data protection, and regulating the internet, and we will be closing with audience questions and closing remarks. But before we get to the fun part of the event, please bear with me through these housekeeping rules for the discussion. I would like to ask the panelists to please limit your answers to around 5 minutes to be mindful of each other's time. We are in different time zones and some of us are getting less sleep than usual because of this discussion. We would like to remind everyone that this discussion is aimed to bridge the gap between the ILC and the younger demographic. So we would like to keep things like to talk about things that are relevant to youth in a language that is understandable and maybe doesn't necessarily require a background in law, which I of course would appreciate, as I am myself a law student as well. I won't be addressing the same questions to each and every one of you. However, feel free to build upon answers previously given by the other panelists. And to our wonderful audience, if at any point you have a question, please feel free to drop them in the chat box. Our coordinator, Keita, who was the mysterious voice addressing you before, will be going through them, and we will make sure to give word to you when the time comes at the end of the discussion. It is undeniable that there exists a gap between the youth and the ILC, and those without a law degree rarely know what the International Law Commission is. And so our discussion today with our 5 excellent panelists will revolve around why that is, how we can move forward, and especially with regard to the youth relevant topics I mentioned beforehand. We are looking to bridge the gap, so to say, and we're doing this with the help of Professor Asada from Japan, nominated by Japan and the United Kingdom. Welcome, Professor.
Thank you very much.
Nice to see you, Professor. Professor Okowa from Kenya, who has been nominated by Kenya and the United Kingdom as well.
Hi, good afternoon. Yeah, good morning, depending on where you are, but nice to be here.
Great to see you. Ambassador Orzabal from Argentina, nominated by Argentina.
Hello to everyone.
Dr. Paparinskis from Latvia, nominated by Latvia, Estonia, and Lithuania.
Thank you, Ms. Knipša. Pleasure to be here.
Thank you. And of course, Dr. Ratings from New Zealand, nominated by New Zealand, Australia, Canada, and most recently, Sierra Leone.
Thank you very much for the invitation, and it's a pleasure to see everyone. Thank you.
Well, thank you for the lovely introductions. You will have ample chance to speak on your priorities in your candidacy to the ILC within the questions posed to you today. Turning to our first topic, making the ILC more understandable. I would like to start with general questions about the role of public international law, the United Nations, and the Commission itself. So, for example, Professor Okowa, why and what aspects of international law do you think are most important to the younger generations, and how does public international law affect our daily lives?
Well, that's a very interesting and a very difficult question. I think I will start by rephrasing it. That first of all, most young people don't actually know much about the Commission or its work or what it does or what should be relevant. So the first thing is, I think we need to engage in an exercise of just publicizing what the Commission does, perhaps its success stories. I'm not even sure law students, public international law students in universities, honestly, unless they're graduate students researching, trying to grapple with the intricacies of state practice, would even know what the Commission does. But the Commission has a long trajectory of success stories. We could start with the Vienna Conventions on the law of treaties, the Vienna Convention on diplomatic protection, and even though the Rome Statute itself was not a product of the ILC, you know, the ILC can claim parentage to it. The draft statute was an ILC product. The substantive norms in the Rome Statute, in fact, emanated from a long project undertaken by the ILC on the draft code on offenses and crimes against humanity and crimes against the peace. So in one sense, perhaps just a question of publicizing what it does. In a more general way, I think in the form of leaflets, the way national governments do. After all, it's funded by the UN, it's eventually funded by member states. So the democratic norms that apply within national systems ought to apply to all UN organs, including the ILC. Now, the topics that are relevant to the youth will only be taken on board if, in fact, the youth engages in that process. And that's a very complicated question, because until now, it's been taken as a given and an unquestioned given that the ILC serves the interest of states and of the Sixth Committee. And one argument why it should be made that it's a technical body, that essentially we need to maintain that purity of relationship, because the other forums of lawmaking, it's not the only lawmaking body, it's not the only body charged with codification and progressive development. But to the extent that it plays a key role, I agree entirely that citizens, students of international law, interested individuals ought to know about it, ought to know about who sits in it, and ought to know about whether the democratic values that involve elections or that apply to domestic elections also apply to the ILC. So I would start by saying that it shouldn't just be around elections, that youth can demand to know who is going to be elected in the ILC, who's going to speak in their name, and the processes by which they are selected. So one way of going around this is ask learned societies to actually approve who should be nominated to the ILC, because that will require some level of engagement, whether it is the Latvian Law Society or the British branch of the International Law Association. All these have students, academics. So ultimately, that's one way of fostering an agenda without making it very artificial around elections. You would know in a 5-year cycle who's in the running and why should they be in the running. And you could have a straw poll, ask at conferences, who do you think your country should nominate to the ILC? At the moment, frankly, unless you're me or Penelope or Martins who's interested, most of us never get to know the processes by which people get nominated. So I think the start by making it a democratic process. And if candidates want to be considered, let them address everyone, including the youth, what's on the agenda, and what the youth can then have a dialogue about what they want to be included. So for me, the main problem is at the moment, the ILC election, the ILC project is generally shrouded in mystery. No one knows who's on it. It doesn't seem to operate through the normal lens of democratic norms that govern accountability in most states, in how people are elected, in how people are accountable to those who vote for them. So I would start with that. And if you have that dialogue, then at least the youth would be able to have an input, ordinary citizens, on what they think should be topics for inclusion. So that's where I would start.
Thank you, Professor Akova. Dr. Writings, you have spoken about user-friendly ILC decisions and making it kind of more understandable for everyday people. Do you have any examples of how you would do that if you were elected to the ILC?
Thank you very much. That's also a very interesting question. The most important thing is to actually have the outputs of the International Law Commission actually understandable for everyone. This includes not only the people to whom they're specifically directed, which is normally the legal advisors in states, but also to the normal person who's actually trying to understand international law and trying to look more at how international law is applied. The most important thing is communication and engagement. Professor Okawa has talked about the need to have democracy, but I think it's also the need to have both visibility and engagement. The more that the International Law Commission is engaged with those with whom it actually interacts and for whom international law applies and serves, then the more it can actually be engaged and relevant for the international community, including young people. So engagement is really important. Nowadays, what is really one of any advantages one could say about COVID has been the use of virtual platforms. And this is now the way in which you can actually have both publicity about what the International Law Commission does and also engagement with it. It's no longer should be seen as a group of independent experts which sit in an ivory tower in Geneva with no engagement or with a very limited engagement, except with a limited number of people in the international legal fraternity. By opening it up through virtual platforms, which the ILC is now starting to do, this will actually help with both visibility and engagement. And it will also help with making what they say more user-friendly, and so that they can communicate in a more practical sense about what it is that they're doing and what it is that they're trying to achieve. So I think that with visibility, engagement, and a more user-friendly approach, this will enhance the relevance of the international community, including for the young people.
Thank you, Dr. Ridings. Professor Asada, public international law is largely within the global legal fabric, so to say, but how would you make this change or jump to visibility of the ILC within young people and making it more understandable also as a part of the legal system as a whole? Do you have any ideas or propositions in your mind already?
Thank you very much. In posing this question of relevance of ILC, I think there are several aspects of the relevance. One is, as you discussed, relevance to the young people. But I think we should think about this question from some different perspective, including the relevance of ILC to the international community of states as a whole. Particularly compared with its past. I think ILC has a glorious past. In the past, as Professor Okawa said, the Commission drafted such important treaties as Geneva Conventions on the Law of the Sea and Vienna Convention on the Law of Treaties and other very important treaties which I learned a lot during my university student. But since 2000, however, the ILC has drawn up only one treaty of comparative importance, that is comparable importance, that is the Convention on the Jurisdictional Immunity of States. But during the same period, I think ILC produced important documents such as articles on state responsibility and the guide to practice on reservations and conclusions on subsequent agreements or subsequent practice. I think there is a difference between the past and the after 2000, the year 2000. In the past, ILC drafted a set of articles which has eventually become a formal treaty. While recently, it tends to produce a document which is not necessarily intended for a treaty, and they are called guidelines and principles or conditions, conclusions. So some people criticize the work of the Commission as by saying that ILC must be an organ to codify international law in the form of a treaty. I think this is there is some truth in that, and that is one aspect that in which the ILC has been criticized as to its relevance to the international community as a whole. However, the tendency toward non-legal documents in the ILC's work is sometimes inevitable because to take the law of treaties, for example, it is difficult to produce a new legally binding document in this area because there is already the Vienna Convention on Law of Treaties. If the ILC produced a new document legally binding, then there would be a problem of which is prevail. And also if the document copies Vienna Convention, then it will be superfluous. So the only solution is to produce a non-legal guidelines such as the ones on reservations to treaties. Others criticize such an exercise as producing an unnecessary imitation. Perhaps there are some duplication in the text, but I think that is an unfair labeling. The Vienna Convention is not perfect, and there are questions that have not been dealt with by the Convention. The legal effect of, for instance, impermissible reservation is a case in point. And there are lots more for the ILC to do in order to clarify the law concerning treaties, the most important source of international law. These fundamental rules of international law are extremely important for the long-term stability of international relations. But at the same time, it is equally important for the ILC to respond to the immediate and obvious problems that the international community is confronted with. A representative example is the question of sea level rise. As this is a topic of our second round, I don't talk about it too much, but I think we should, or ILC should pursue a kind of two-track approach, that is to tackle the questions which needs a swift resolution, such as the sea level rise or natural disaster or cyber activities. But at the same time, ILC is an important organ to address the legal questions that are important for long-term stability of international relations, such as the law of treaties, international responsibility, state succession. So I think we shouldn't compare our past and present performance of the ILC because in the past there were a number of topics to codify, but thanks to the successful work of the Commission, the situation is different now. This is my answer to the question of relevance, but this is not necessarily related to the ILC's relevance to the youth, but we should talk about the a more broader perspective of the ILC's relevance to the international community of states as a whole. Thank you.
Yes, thank you, Professor Asada. Building upon that, I know you just said not to compare. However, Ambassador Oyarzabal, what would you say would be the best way to uphold the legacy of the Commission, but also ensure that the next generations benefit from the work that has been put in and we continue building upon it as an international legal community?
Thank you very much. Let me start by saying that it is a real pleasure to be here and an honor to be with such distinguished group of panelists. Thank you for the question. I think it's extremely relevant. I would say that for the very generally, and then I will go on more detail, but I would say that for the Commission to uphold to its tradition of codification and progressive development of international law in a number of important issues, as Professor Asada just said, it needs to evolve. It needs to evolve with the times. I think that is fundamental. I think the Commission, the work of the Commission is going to impact the most the next generations. And by that, I mean the young people who in the near future are going to be sitting here, being candidates to the ILC, being legal advisors to their foreign ministries. They are going to be law professors. They are going to be influencing the opinion of states and the practice of states. So, I would go a little further, and I would submit that of course the work of the Commission needs to continue on classical issues. But I think for the Commission to become relevant, besides, of course, and I think both Professor Okawa and Professor Readings pointed out the importance of visibility and making the work of the Commission more understandable. I think there is no doubt about that. But I would submit further that the Commission needs to basically dive in the special regimes, those issues that are not only important, but are also pressing. And there is an urgent need of the international community to deal with them. Some of them, of course, the Commission has included them in its program of work, but I think there are still a number of issues that where the Commission can play and can act as a unifying force in the face of fragmentation among the different bodies of laws and the proliferation of forums that Professor Okawa mentioned about. I think the Commission needs to look for innovative ways to engage. Of course, the young people, but also the Sixth Committee, because at the end of the day, the Sixth Committee, we all know they are young delegates that influence their capitals with their inputs. So I think addressing and engaging the Sixth Committee both means engaging states and engaging young people. So it has sort of a double benefit. I think I think some colleagues already mentioned that. I think the work of the Commission is not an academic exercise, and of course, if we do not take into account the practice of states and the opinion of delegates, then we run the risk of going into a program of work that is not relevant. I think that another way of engaging young people is through scientific institutions and individual experts. I think more and more, as the Commission engages with specialized areas, that is becoming unavoidable. And I think the Commission clearly needs to be attentive to civil society concerns, particularly in issues such as environmental law and cybercrime or cyber or norms in the cyberspace, that plays a particularly important role. So that would be, I think, to summarize, I would say the Commission needs to jump in, and I'm saying this with utmost respect. I think the work that the Commission has done in the law of treaties and in relating to state succession, I think it has been extremely relevant. But I also think that at this point we can spare another topic in those areas, and we need to deal with issues that are pressing, that are really urgent. I think the Commission is entering a very interesting phase, because several issues are going to be ending either this year or next year. So there is an opportunity to engage with the Sixth Committee, with other relevant stakeholders, I would say, and come up with issues that really have an impact on the new generations.
Thank you, Ambassador. And turning to the last panelist who has not spoken, Dr. Paparinskis, building upon what was just mentioned, youth activists are often the young people most heard in the international community. And as youth activists, we tend to look for tangible results, but taking into account the nature of international law and the work of the Commission itself, how can we bring to light the results and achievements of the Commission and how it benefits young people more effectively?
Well, thank you, Ms. Knipsch, and I guess it is a challenge speaking last after such wonderful interventions by everybody else. Let me, I think, just add 2 points, not to repeat anything. And I think particularly, I thought that Ambassador Oyarzabal's intervention was interesting in highlighting the various ways how topics may be relevant for the youth. And that is really a fascinating perspective and really an interesting way to reflect upon the ILC's work. And one way of looking at it is that there could be, one could say, a number of layers of interest. There could be projects and subjects that are directly, as it were, substantively related to the protection of youth. And if we look at the work that the International Law Commission has engaged with in the recent years, the work on prohibition of crimes against humanity, where children and youth could be particularly victims. I think the additional layer of gender-based violence could be particularly an important subject of engagement with. Protection of persons in the events of disasters, also mentioned. So I think these are projects where the youth perspective should inform the International Law Commission's work, because the particular rule has at its object the protection of youth. The second one, I think, is important at a more macro level, where youth is important because of the intergenerational equity that is echoing through the particular project. So if we look at the current work, protection of atmosphere, the point made by Professor Asada, sea level rise in relation to international law. So again, if we look back at the recent years and decades, transboundary water rules. So these are things that are meant to regulate and provide rules not merely for this moment, but for decades and centuries to come. So plainly, today's youth, today's children, tomorrow's decision makers or persons who should be protected are very important. And then I think that there are, I suppose, the foundational rules that do not, I think, directly track either of those, but provide the important aspect of predictability. Now, how do we filter those concerns? And I must say that I was thinking about with a slightly different institutional hat on. So one of the things that I do is that I'm a member of the management board of the European Union's Fundamental Rights Agency, which is a key European institution that deals with legal and socio-legal matters. And one of the things that they have looked at is communication about rights. And the conclusion, I think, will probably not be shocking to anybody of us who is bombarded by information through WhatsApp, Twitter, and email 24/7, is that nobody, and I think, nobody, slightly simplifying, ever reads everything that is longer than 1 page. So the format for communicating is a 1-page picture with bullet points, a video up to 2 minutes, or a vlog up to 1.5 minutes. That strikes me as something that is just the next step forward after the excellent performance online of the ILC that I think many of us has observed. We can very easily imagine the Commission's chair, special rapporteurs briefing in that blog information about the importance and issues. And of course, not everybody is online, but I think that the Venn diagram of people being online and people seriously engaging with international institutions is increasingly approaching the circle. And then there's a broader point which goes to the legitimacy of the institution, and simplicity and clarity of messaging to youth will also be simplicity and clarity of messaging to all states, including smaller states that will not always necessarily have the time and other resources to go through hundreds of pages on all the topics. Ability to express the key points succinctly, I think, would tick all those boxes. Broader engagement with the online community, broader engagement with the youth community, and engagement with the true international community, all states, including smaller states that often have a little bit less of the say. Thank you, Ms. Knipsch.
Thank you, Dr. Paparinskis, and thank you to all the panelists for their answers under this first section of our discussion today. And moving swiftly on to different aspects of climate change. It has proven time and time again when surveying young people, both locally and internationally, that climate change and tackling the climate crisis is the top priority for the younger generation. However abstract or larger than life this issue might seem, there are facets to it that can be influenced and molded through instruments of public international law. And now, as Dr. Paparinski spoke last, I would like to address you first under this question, if I may, regarding the issue of rising sea levels and public international law in relation to climate change. How would you impact or influence this aspect of tackling the impending issue of climate change if you were to be elected?
Well, thank you, Ms. Knipsch, for giving me the floor again. And of course, it is an important topic. I imagine that a number of speakers, including Professor Osada, would want to weigh in on that. I think this is something that the International Law Commission is already dealing with. As many of you will appreciate, there is a study group on sea level rise in relation to international law. In fact, I think literally now, since the beginning of June, International Law Commission has been discussing these issues. And that, I must say that strikes me as a very good example, almost like the gold standard of the role that the International Law Commission can play in the modern international community. This is a point where a number of states, particularly small Pacific island states, took the lead and identified this as an issue of great, indeed, existential importance. And the International Law Commission appreciated that point and created the study group, which I think is often a much lengthier process. So I think, appreciation of a clear challenge to the international community is important. The second is that the way how International Law Commission approached it strikes me as methodologically fascinating, because mostly, I think that's sort of also a theme that a number of speakers made, that International Law Commission looks either at generalist topics, treaties, responsibility, things that are important for every field, or at things within specialist fields. And law of the sea is something altogether different. The International Law Commission has taken the phenomenon of sea level rise, as identified by the Intergovernmental Panel on Climate Change Special Report, and use it as an analytical lens to see how it impacts three well-established fields of international law: sea, statehood, and human rights. And in all of these contexts, International Law Commission acts to some extent as a General Assembly think tank, raising the questions and identifying the trends, but also increasingly, and I think that is also a fascinating element, as a hub around which states can engage with the topic, both individually, but also particularly, I have found it fascinating, and this is sort of again builds on the theme of importance of involving smaller states, of groups of states like Pacific Forum, for example. And so I think that one of the very hard questions, so let me just sort of say a bit more about one and then two shorter points about the others, is how to balance the law of the sea and the regime that is mostly deals with law of the sea, United Nations Convention of Law of the Sea, the so-called Constitution of the Oceans, an incredibly important achievement from 1982, indeed not extremely easy to imagine the contemporary international community achieving consensus, which provides for simplified land dominates the sea approach. Once we know where the land is, certain rights correspond to that in the sea. But it does not address the challenge arising out of the sea level rise. What happens, as the special panel suggested, if within the next century sea level rises from 60 to 110 centimeters? And that is a question whether it is possible to conceive of a way to approach these issues that would protect both the overall regime of UNCLOS and also protect the most affected and states that have least contributed to the factor. And there have been very interesting regional developments in that respect. Statehood and human rights raise to other questions. I think I'll leave human rights to other colleagues who are more expert on this, but let me just say on statehood, because I think that there's a particular Baltic states angle here. The question of whether states necessarily have to have control over particular territory for their existence. which would probably be the classic approach of international law. And that is something where Baltic states would probably say that even though we did not have much of factual control over our territory for 50 years, we did maintain legal existence. So that could be a very interesting precedent, a comparison on which to build. Now, this is not the only place in the international community where discussions about this take place, but it strikes me as a very interesting methodologically, analytically, and politically as a hub for bringing all these developments. I'd be extremely keen to contribute to that if elected. Thank you.
Thank you, Dr. Paparinskis. There are, of course, different facets to tackling climate change. And Professor Asada, I believe that Dr. Paparinskis mentioned you as another expert on law of the sea and just prosperity and peace. And how would you tackle the issue or approach solving the issue of climate change or the impending climate disasters potentially, which would need very large intervention from the international community? Do you have any ideas or what is your perspective on this?
Thank you. Yes, as Dr. Paparinskis said, the question of civil rights has a lot of aspects, including human rights, statehoods, and also law of the sea. But as he said, this is one of the most representative topics that need to be tackled with a sense of urgency. It is not a question of urgency, but it also concerns many states, not only small states, but many states, and covers many areas of international law, as I said, including statehood or human rights. Furthermore, it involves a very difficult international legal question. All these features make this topic very much fit into the topics of ILC, and the ILC has already started work on that. There is no need to point out the urgency or vital nature of the problem, but as you question about the law of the sea aspect of the question, I will limit myself to the this aspect of the question. The legally difficult part of the question lied in the fact that we have UN Convention on Law of the Sea, UNCLOS, now in force for over 160, nearly 170 states plus EU. Most of its provisions reflect customary international law as well. As South China Sea Arbitration Award declared a couple years ago, the UNCLOS, UN Convention on the Law of the Sea, provides a comprehensive system of maritime zones. Thus, as he said, as Dr. Paparinskis said, the convention has been called the Constitution of the Sea or Constitution of the Ocean. But when it was drafted in 1980s, the climate change was not a problem, and there was no question about sea level rise. So there's nothing which reflects the risk of sea level rise in the convention. Now, I think few people question the rationality and validity of the argument for adjusting the law of the sea to the reality of sea level rise. But the question is how? Although the UNCLOS contains amendment procedures, they are really complicated. Indeed, as many as 5 articles are devoted to amendment procedure. This is unprecedentedly heavy type of articles. It requires a proposed amendment to be adopted by consensus at the amendment conference, and then the adopted amendment to be ratified by as many as 2/3 of the states parties, meaning that ratifications of some 110 states are currently required for the amendments entering into force. Considering the complexity of the question and the high threshold of the requirement for amending the UNCLOS, it is extremely difficult to resolve the question by amending the convention. Perhaps we should think of alternative approaches to this question. For that purpose, we need a strong political will as well as learned legal wisdom. For the latter element, I think the ILC is best suited. My humble idea about resolving this question is not amending the UNCLOS, but through the path of establishing a quick establishment of new customary international law. Provided that there is a consensus among states on how to deal with the question, for instance, by fixing the normal baseline of state at some particular point of time, one of the solutions to this question may be to produce a recommendation type of document within the framework of ILC, and followed by UN General Assembly resolutions inviting states to follow and endorse those recommendations. And then states act in accordance with such recommendations and quickly establish custom international law, which could supersede the UNCLOS. I think newly established custom international law prevail over treaty law if such is the intention of the states parties to the treaty, in this case, the UNCLOS. This is by virtue of the rule of lex posterior. Without this kind of exercise, I think if you apply the UNCLOS as they provide, then we could not resolve the question of sea level rise, including the maritime entitlement, etc., which particularly affect small island countries. Thank you.
Thank you, Professor. Speaking on the political will, Ambassador Oyarzabal, battling climate change with diplomacy, how is it different from battling climate change through the lens and the platform that is the ILC? How would your approach differ? And of course, feel free to comment on the questions previously posed.
Thank you very much, Mr. Knipche. I hope that I pronounced your last name right. Yes, I think the questions, both this question, but also the questions of my colleagues are fundamental importance. Let me, before addressing the point that you just raised, let me say that I think that climate change, as one delegation put it in the debate in the 6th committee in relation to sea level rise, is a typical intergenerational issue. And building upon what I said in my prior intervention, I think that the current generation must accept to work to establish a legal system and to deal with it comprehensively, both from the perspective of lege ferenda and lege lata, or I would say not just from the perspective of lex lata, but from the perspective of lex ferenda. I think the question that you addressed to me raises a very important issue, which is what is the role of should the International Law Commission take into account political considerations in its line of work? Clearly, I believe that the ILC doesn't work in a vacuum. And of course, its work is ultimately addressed to states and to help codify and to develop international law. And from that point of view, it's a very function of the committee. And it should always have an eye on political developments, particularly as more and more, when it comes to new issues, they influence the development of the law. political negotiations, the work of NGOs, non-political forums, I think it all influences the law. And of course, the ILC cannot not take that into consideration. But I would say that one thing is to do that, and a different thing is to be led or influenced unduly by political considerations. I would submit, and of course this is a controversial issue, that the ILC should not impose upon itself conditions beyond the limitations that may be needed to make the work manageable and useful. If we speak specifically about issues of environmental law, the protection of the atmosphere is a clear example that the conditions that the unprecedented conditions, I would say, that the Commission imposed upon itself are limiting its work and in the field. I think the work already that the Commission has undertaken is already very ambitious, but I think the limitations that the Commission imposed upon itself are restraining, are preventing the Commission from reaching its full potential. And again, I think that, of course, political considerations cannot be overlooked, but it is ultimately the job for the Sixth Committee to comment on the topics that the Commission proposes and eventually to renegotiate the Commission's outputs, at least when the product is intended to become a treaty. Professor Sada mentioned in relation to this issue that the Commission should go perhaps not in the direction, if I understood correctly, not in the direction of a treaty, but customary international law. I very much agree, and it is in the work of developing principles and guidelines is where the Commission can be very influential, because in fact you don't have there this possibility of negotiating with the Sixth Committee. The Sixth Committee lacks the possibility to actually renegotiate the Commission's outputs. So that's a very, I think it's a very interesting and probably the only useful approach at this point, particularly when it comes to sea level rise. But it's also a way that the Commission has to look very prudently. When it comes to climate change and rising sea levels, I agree with the colleagues who spoke before me. I think they are incredibly important areas where there is a common concern of humankind, and that is shown by the remarkable, I would say, degree of support in the Sixth Committee when the Commission decided to include the topic in the current program of work. I think Professor Paparinskis, I think she mentioned that this is a global issue. It's very true. It's a global issue, and it's not a theoretical issue. Sea level rise threatens the very existence of states and the populations who live in low-lying coastal areas. Make no mistake, this is not a problem for the small island developing states. Almost 4/5 of the countries of the world have coastlines. And numerous maritime boundary disputes are also pending. And if, of course, while the UNCLOS and state practice favors the stability of maritime delimitations, which have been already effected, there is much less clarity when it comes to the existing claims to the entitlement to maritime spaces. Then, of course, there is the issue of the obligations of states with regards to the protection of persons affected by sea level rise. I think this question goes to the very heart of it. In theory, the report of the study group should be done in this quinquennium, and this is very much the issue that we are going to have to discuss if elected in the Commission. Which is what to do with the conclusions that are presented for the ILC consideration and for the Sixth Committee. If I can take one more minute, I would also mention that that of course the issue of rising sea levels is not the only issue that is related to environmental law. The Commission has not shied away in the past from environmental issues. The question would be whether also climate change per se should be the subject of the Commission's work, and that is something that perhaps we should consider beyond the problems that come up in relation to zone depletion or to the law of the sea. There are many other problems. Climate change and environmental law their implications are cross-cutting. So that is also something that I think that we should, probably the ILC should look into it. I guess I already went. Thank you. I'm sorry.
Just a little bit. Thank you, Ambassador. Now turning to, it was my intention to bring up different aspects of climate change and its influences. Professor Okowa, what would be, considering the urgency of the matter, what would be the first facet to tackle? Of course, taking into account the rising sea levels, but also the human rights aspects of climate change, the future of potentially sustainable jobs, which is spoken a lot about within the framework of the United Nations. Also the aspect of gender equality within climate change. Is there any one facet that you would prioritize when beginning to tackle it in a legislative framework within the ILC? Professor, your mic is off. Terribly sorry.
So the first thing I want to say is generally to contextualize it a bit in terms of what the possibilities of what the Commission can achieve and can do. And first, I think the sea level rise as a work of a study group may be seen as a taster. And there are very realistic reasons for that, because the International Law Commission, as is known or not known, depending on how much law of the sea you've engaged in the past, was involved in the drafting of the 1958 conventions that originated in an ILC project. By the time, in the late 60s, by the time the project for negotiating the 1982 convention was taken on board, there was a feeling that it raised a multifaceted range of issues that could not be dealt with by just a technical legal group. So the matter was, as it were, passed on to a whole comprehensive conference that worked on it for several decades. So there is an element of reality that when the issues are so complex and interrelated, it makes more sense maybe for the ILC to tease out the issues. And we saw this in relation to an issue I talked about earlier, which is completely different field. But on the Rome Statute, the ILC produced a draft statute, a study group, and then that's taken on by other bodies to develop the law in a political context where it can be made more meaningful, more relevant. So I suspect that part of the issue surrounding climate change is we all know just how contested and how politically difficult these questions have. Anyone who followed the negotiations of Kyoto, Paris Agreement knows that this is a matter in respect of which if the ILC produced a draft treaty or anything which is so prescriptive of that kind, chances are it could be regarded as relevant or go nowhere. And the ILC, I think, has taken on board its track record on environmental issues, when too ambitious, has sometimes not produced very useful results. One of the topics that the International Law Commission engaged with for almost 30 years, and some of you may be familiar with this, was the ILC topic on the liability of states for injurious consequences of acts not prohibited by international law. Now, this went on for 3 decades in the face of mounting opposition within the Commission, but also within the Sixth Committee, only to realize that at least the project in its original form was entirely unworkable and essentially was abandoned. They jettisoned it. So I suspect that's one reason why in a complex issue such as the sea level rise, so for, There's the law of the sea aspect, and in a range of questions in respect of which, as Professor Sada, Professor Yasabal had already talked about, there's already a convention, a comprehensive convention, the provisions of which in many respects are regarded as customary law. You can't reinvent the wheel there. So I think there's a natural reticence to raise those questions within the Law Commission, because so having a study group may point to some of these issues and leave it to the political organs, because at the end of the day, the ILC is an instrument at the service of states. Now, whether or not on the successful conclusion of the sea level rise, what happens to it, I suppose, will be a matter for the sixth committee to discuss. But there's also a related component, not just the law of the sea component, there's the statehood component. And as some of you know, of the original topics that the International Law Commission proposed to codify, the only one that has not been codified or been comprehensively dealt with is the question of statehood, the criteria of state or recognition of states. This has been proposed by a number of people, including the late James Crawford, but also was in one of the original topics, because the feeling was it will be politically sensitive, and whatever comes out of the International Law Commission may not garner support of states, may not get that political support to make it meaningful. So the International Law Commission is not an academic institute, it's not going to deal with. There has to be a dose of political reality about what it can achieve. So I suspect in that sense, the study group is teasing out the problem areas and essentially leaving it to political bodies to decide what direction to take it, whether it's in terms of amending the law of the sea convention or in terms of having new guidelines that states should take into account in the context of maritime delimitation questions of statehood. But that also means that on the completion of a topic like sea level rise, there's nothing to stop the Commission from taking on board new climate change related topics. So for instance, one of the hot topics within domestic litigation is rights-based strategy for litigation. You know, how can you use human rights norms? How can you use constitutional norms? And how can you use the existing body of international law, including the Paris Agreement, to create an enforcement strategy and to impose duties on governments which are actionable and justiciable within national legal systems? It's therefore an interesting question whether those norms, commitments taken can also be made justiciable in an international context. And if we're going to use a rights-based strategy as a way of enforcing those international norms and international obligations, what form should this rights-based strategy take? Who should have the rights? What are the recognized rights? What form assistance would litigants get in bringing up these cases? Will domestic legal systems, will the international system be required to recognize some form of public interest litigation? The story of erga omnes obligations as to international lawyers is well known, is actually a checkered one. But climate change now forces us to rethink whether or not we can have a set of norms, concrete workable norms, where these obligations in the climate change sector can be actioned upon. So I would welcome the opportunity for the Commission to rethink how a rights-based strategy can be used by states, both within national legal systems or internationally, to, as it were, litigate and enforce undertakings taken in relation to climate change. And that may also relate to questions which my colleagues have talked about adjustment. How should we support states to adapt and adjust to the effects of climate change, whether it's sea level rise, whether it's desertification? And if we're going to, what form are we going to make these forms of adjustments take? And can states actually rely on those commitments in an international forum to create actionable rights? It will be interesting if the Commission can really fully take on board a rights-based strategy to climate change that is workable, that would create obligations for states as well.
Thank you, Professor. And now turning to you, Dr. Ridings, of course. Sorry to keep you waiting there. And again, probably the most difficult job to speak last in a panel as this. However, continuing on, also your proposition, which I think is incredible, about the user-friendly ILC decisions, and building upon what Professor Akova was just speaking about. How do you see the use of the ILC as a tool for tackling climate change, but also making it understandable and approachable and accessible while tackling these different facets that climate change poses.
Thank you. So I think it's really important that the ILC work that is currently doing on sea level rise, that it's actually understandable. So I think they're doing a really good job. At the moment, the co-chairs of the study group, which are looking at the maritime law of the sea issues, through explaining in virtual platforms the basis for their study work, and I think this is really good. But more importantly, it's really essential that each of the three elements of the sea level rise topic, that each of them is put down into a level which is understandable for states. There needs to be a way in which the International Law Commission can actually speak to the Sixth Committee, to states, so that in a way so that you don't need to read a 700-page report in order to get the key elements of what it is that's actually being talked about. Because, to be quite frank, a 700-page or even a 200-page report is simply going to sit on a shelf. So the issues are very complicated. I totally agree. But there needs to be some way in which to hone those down. What the International Law Commission is doing is that it's, in many cases, it develops in draft conclusions, draft principles, which set out, in very short form, what the key conclusions on a particular topic, which might be protection of the atmosphere, is the most recent one. These are not sufficient in themselves because they don't give enough background, and they don't have enough context to actually be able to understand them very well. So they're accompanied by the commentaries, and the commentaries are extremely important, but the commentaries cannot be used as a way in which to incorporate different perspectives. And so in an attempt to draft a consensus report, because every time you try to draft a consensus report, you end up by making it so much larger and so not understandable at all. So there needs to be a way found to really hone down in the exact issues. But returning to the issue of sea level rise, some of the interesting thing about sea level rise, and Professor Asada has already mentioned this in terms of the Law of the Sea Convention. What's really important is to actually identify the principles in the International Law Commission, in the UN Convention on the Law of the Sea, which actually can drive the potential solution in this area. So, for example, some of those principles have already been mentioned about predictability and stability of boundaries, and the legal security which the Law of the Sea Convention brings. But there are other principles as well, such as equity and fairness. And stemming from this is the whole idea that countries which are affected by sea level rise as a result of climate change, to which they did not contribute, should not be penalized as a result of that. And similarly, there's the principle set out in the preamble to the Law of the Sea Convention about the importance of a just economic international order. So the main aspect of this is the Sustainable Development Goals. And so it's really important for especially small island Pacific states to be able to develop in a way which is within their ability and within their capacity, and be able to adapt to what may happen in the future with respect to climate change. In a way, these principles, which are understandable and and clear, if they are used as a basis for an outcome, then the outcome is therefore more understandable. So I would also like to, it seems to me, but the climate change as well, is it's not just an issue of sea level rise, but the International Law Commission could also look more broadly at climate change and the issues such as, Professor Okawa has already mentioned the domestic litigation, the rights-based litigation. There would be a really useful thing which the International Law Commission could do by actually looking at the various domestic litigation that has taken place in various countries and actually encapsulating those to try to develop sort of a synthesis of all those different litigation decisions. That would actually be extremely useful to do that. And another thing which would be also very useful is we have the Paris Agreement and we have the nationally determined commitments. There's not a lot of clarity about what that actually means in practice. What are the, is it simply a bottom-up approach for the Paris Agreement that you determine your nationally determined commitment and then you can alter it downwards or you can change it as circumstances? Or what does it actually mean? So trying to encapsulate some of these issues in a succinct manner would be beneficial for those who are actually looking at the outputs of the International Law Commission.
Thank you, Dr. Ridings. And seeing as our time is swiftly running out, as one would predict would happen when you place a law student in front of 5 brilliant legal minds and let her ask questions, I would like to now turn to the last part of our discussion today regarding data protection and regulating the internet. And I would like to kind of broadly address this question, so we also have time to take the questions that were sent in prior to our discussion and have been written in now. Should we enforce human rights online, and what is the ILC's stance and role in this? Something of concern to young people is the limitation of freedom of speech online, which traditionally may only be, of course, limited by the state, but we are seeing more and more frequently this kind of free-for-all online of limitations and regulations imposed by certain companies. And how can the international legal community and the ILC react to this, both in terms of cybersecurity and ensuring the implementation of human rights online? Maybe we could start with you, Professor Asada. What is your take on this?
Thank you very much. I think the question of cyberspace or cyber operations has many aspects, and not only human rights aspect, but it covers many areas of international law, perhaps covering almost all major areas, from sovereignty to state responsibility, of course, human rights and law of the sea, space law, diplomatic law, use of force, law of armed conflict, neutrality. Almost all areas of international law is relevant to this question. I think we should rather classify the rules of international law in terms of application of them to cyberspace or cyber operations. So not only the human rights question, but also I would like to classify the overall rules of international law into rather two, three categories. One of those rules that can be applied as they are is the first category. Those rules that can be applied as they are without any change or without much difficulty. Example of these rules are those on diplomatic immunity. For example, the premises of diplomatic mission and cyber infrastructure within the premises would remain inviolable, even if illegal cyber operations are going on inside these premises. The same is true of inviolability of archives and documents of the mission. I think the second category is the area where the existing rules are relatively clear, but whether they can be applied directly to the cyberspace as they are is unclear, or the area where cyber activities may introduce a new dimension into the rules. For instance, in the COF channel case, the ICJ referred to every state's obligation not to not to allow knowingly its territory to be used for acts contrary to the rights of other states. But if a hacker group located in state A carries out destructive cyber operations against state B, using cyber infrastructure located in state C, it is unclear what state C is expected to do when it becomes aware of that plot, particularly state C's ITC capability or capacity is limited or poor. Other rules belonging to this second category includes those concerning the definition of armed conflict, whether cyber operations alone may reach the thresholds of armed conflict. The definition of armed conflict is very important because that is the starting point of the application of law of armed conflict. This is the second category. The third category is the area in which the existing international law is in itself not clear. For instance, it is unclear whether and under what conditions armed attack by non-state actors not attributable to any state would be subject to the use of force in self-defense. The ICJ has failed to declare the law on this point so far. The same uncertainty remains in case of a cyber attack by non-state actors not attributable to any state. So we can categorize, or we can classify the international law rules into these three categories. And the first category, there's no need to change the rules in the context of cyber space. I think there's no need to talk about more in the ILC or anywhere. Perhaps other than reaffirming the applicability of those rules to international cyber operations. On the other hand, the second and third categories of rules may be worth examining at the IDC in relation to cyber activities. However, I personally think that it would not be easy to deal with third category of rules in cyber context because they are originally very difficult and involves difficulties in identifying the current rules of international law. So perhaps the second category of rules that the rules which is relatively clear, but the cyber operations or cyberspace may input some uncertainty should be dealt with in the framework of ILC.
Yes, thank you, Professor. Sorry, as we are running out of time.
So thank you very much.
No, everything's okay. Thank you very much for your answer. Professor Okowa, what is your take on this, on the ILC's role in regulating essentially the internet and how we can make sure that people, especially young people who are growing up in this digital age, are protected and that the international law community is there for them, so to say?
Yeah, first of all, I agree with Professor Asada that much of international law can already apply to the cyberspace. But there is, in my view, actually here I would come off the fence and think that there is an active role for the International Law Commission to take on board the project, partly because even though there's a large area of international law where the laws, the existing body of rules can apply with clarity to the cyberspace, it's not always clear. It's kind of diffuse. So the first thing, given that the role of the International Law Commission is one of codification, and through that process of codification, it can also act as a catalyst for clarification of norms, I would say that this is a project that the Commission could take on in consultation with the Sixth Committee. And that would, in fact, first of all, have the first level rules or the first generation rules, which will be a point of clarification. And here again, I agree with Professor Sada that there are a multitude of contexts in which this question arises. There's a question of cyber conflict. There's a question of cybercrime. There's a question of intellectual property and theft of intellectual property in all those contexts, and all these raise very different questions. So in relation to armed conflict, for instance, the question here would involve the application of the normal rules of international law on armed conflict, but clearly there would need to be a clarification of how an armed attack would be interpreted when what is involved is a cyber attack. Does it have to result in what element of physical damage, the gravity of the attack, and all those questions? What if the instrumentality of the attack is not a state or even as, but a private actor within the state? What is the responsibility of the state, and what's the appropriate response of the third state, the victim as it were? I think these are all areas where, even though we can say with some clarity that the existing body of international law applies, we may need clarification. And so, similarly, the first primary obligation of all states is that they have commitments under human rights treaties and under human rights instruments, including obligations under Bill of Rights within national constitutions. So their first obligation is to enforce those. Shutting the internet and depriving young people or depriving your citizens of their basic rights in that context would be a fundamental violation of their human rights. So to me, in all these areas, there is actually a need to reaffirm these principles as they apply to the cyber context. There may be other more difficult questions, which, for instance, the question of intervention, an intervention, say, in the internal affairs of a state, which is not coercive. So if you hack into the records or the voter record of the Democratic Party in the US, is that a form of intervention? And is it a form of intervention that is actionable at the international level? What are the appropriate remedies? I think that there are a whole host of questions which need to be asked, which need to be addressed. And also, as I'm sure you know, other bodies have already been working on this question, the Tallinn Manual and all this. So the Commission could take on this task by way of cooperating with all these other bodies to bring a comprehensive framework of addressing all these questions. In some areas, it will be much more straightforward. It will be just a question of clarification of the law. But there are other areas where there will be profound difficulties in how you formulate the applicable norms. And also the reason why this is a problematic area. Sorry, you want me to stop?
No, it's extremely interesting. However, we are running very, very short on time.
I'll just say one point, that the reason, again, why the ILC should really take on this point is national laws are very different here. Some states don't have national laws at all. Some prioritize security, others prioritize privacy rights. You need to bridge that gap. And I think the Commission should and could take on this topic.
Yes, Dr. Writings, do you have anything to add on to the points made previously by other panelists? And maybe what would your advice be to a young person just navigating the online scope if they wish to be a candidate to the ILC one day? How may we protect them in advance, possibly, from damages to their reputation or something like that?
Thank you. It's very hard to add on to the excellent contributions that have already been made to date. Can I just simply, New Zealand, say something from a personal perspective. New Zealand has just experienced the most significant cyber attack in our history. And it was a ransomware attack on a district health system, which involved 5 hospitals, which served 400,000 people. After 2 weeks, the computer systems are still not up because they refuse to pay the ransom, quite rightly. And so this has just simply brought home the real concern about the cyber criminals, which they are, and the need to sort of address some of these issues. I totally agree with Professor Okawa about it's a multifaceted issue. The International Law Commission, because the way in which it's composed, it can actually very well address these kind of multifaceted issues. And so it's actually a really good way. One of the big concerns for young people is, of course, the disinformation, not just young people, for everybody, the disinformation and the potential for using the internet for violent extremism and terrorism, as well as basic reputational damage. There needs to be a way to actually ensure that the internet provider companies actually also assist in controlling those kinds of activities, but in a way which doesn't breach people's human rights. This is something which that you might have heard of the Christchurch Call, which is trying to achieve this working with the internet companies in order to prevent extremism online. It's indicative of a need to actually develop an innovative approach to some of these new issues. And the International Law Commission could help in trying to come up with new innovative ways in which it could study and assess different ways in which to deal with cybercrime and disinformation, as well as all the other issues dealing with cyber that have already been raised. Thank you.
Thank you, Doctor. And Ambassador Oyarzabal, do you have anything to add on to what has previously been stated? Any advice or focus areas regarding the regulation of the cyberspace?
Thank you very much. Yes, in order to be short, because I know that we are running out of time, I would say that I subscribe to what our colleagues said. I would say almost all of it. I think the role of international norms in cyberspace is another intergenerational area, and where there is clearly a common concern of humankind. We could talk hours about the problems raised and whether international law can be instrumental to prevent cyber attacks, particularly from non-state actors. This is clearly a very important question. But I think that the question here is whether international norms and standards in the cyberspace should be included in the ILC's program of work. As you know, in the selection of topics, the Commission has been guided by 3 criteria. One, that there is a pressing need of the international community as a whole. 2, that the topic is ripe enough in light of state practice and literature. And 3, that it should be concrete and feasible. I think that prima facie the 3 criteria are met in the case of the codification and progressive development of international norms and principles in cyberspace. Of course, subject to the fact that the scope of the work should be properly defined to make it workable and to make it useful. Because as my colleagues mentioned before, there is a wide range of potential areas that can be included in this work. That includes the topics that my colleagues already mentioned about cyber espionage and cybercrime. There is also the issue of the use of cryptocurrencies, for instance, to finance illicit activities, including terrorism and drug trafficking. As Professor Okawa said, some rules and principles have already emerged. The Budapest Convention on Cybercrime is, I think, the most notable example. But there is also a set of norms, and then norms question marks of responsible state behavior that has been put together by the UN Group of Governmental Experts on the matter. But the point is that there is no coordination and there is no coherence. And also the topic may entail entering into the field of private international law, which is not a field that the Commission has dived in the past, but it is also now precluded from doing so by the statute. I think that the area, to sum up, provides a great opportunity for the Commission from the perspective of progressive development of international law. It would allow it to tackle the fragmentation of international law, to bridge differences between countries that propose a multilateral convention, for instance, to regulate the use of ICTs, countries that believe that traditional international law does and should apply to the cyber world without much else, and those who call for self-regulation of the internet. And of course, that work goes well beyond the protection of personal data, which is already included in the Commission's program of work, and which is also of fundamental importance. I think, of course, this is an oversimplification, but the point is that the ILC is the only organ that can put order in this wild west of cyberspace, and working perhaps clearly not on a treaty, but principles or guidances, developing legal principles that have emerged from this activity.
Thank you, Ambassador. And of course, Dr. Paparinskis, again, putting you in this most difficult position, but do you have anything to add before we turn to questions from the audience?
Well, thank you, Ms. Knipsch. Not at all to be contrarian. I think that I'm really mostly in agreement with what I have heard, perhaps with some slight differences in emphasis. I mean, I think it would be hard to say that cybersecurity is not an issue for the international community. I think the question I slightly more struggle with, I suppose, is whether ILC is the right institution to answer it. I think it has been noted, you know, last Friday we had the UN group of governmental experts coming to a conclusion. Later this month, so Estonia as a presiding state will raise the question of cybersecurity before the Security Council, something that is addressed regionally. OIS, Inter-American Juridical Committee, a Tallinn manual has been mentioned. Of course, these are things that will be dealt in specialized institutions. Courts and tribunals will deal with them when they come up. So in a way, this is something, the Wild West is already out there. And I guess much would seem to me to depend on the question, because I suppose if we step back and appreciate that ILC in a formal sense is a place for experts. And I think some people would ask whether this is a particular point where interdisciplinary work would be relevant. ILC is a mechanism that is, I mean, glacial is perhaps an unfair term, but it is slow and reflective. And again, some people might say that cybersecurity is an issue that requires a slightly speedier answer than one by the end of next quinquennium. So I think much would, really depend on the framing. Ultimately, ILC can be an extraordinarily useful tool that pushes the international lawmaking process in the right direction. At the same time, I think one should be careful not to duplicate or push things that other people are doing better. So I think sort of the question, is this a legal topic? Is this a topic for experts? Is this a topic at the universal level? And quite conceivably, some questions could be framed that lead to answer yes and some to no. And of course, ultimately, this is something that we would have to single back to Sixth Committee and get a sense of what is the consensus of, or at least the majority swing of the states in that direction. So very, very interesting questions. I don't think that anybody would disagree with that. Thank you, Ms. Knudsen.
Thank you to our wonderful panel. Now, seeing as we are already running over time, I must apologize, but we will be taking just a couple of questions as many youth delegates have written in, but they have already expressed that their questions have been answered through our discussion, which just speaks to the relevance of these topics to youth. And I would like to thank you again for speaking on them so eloquently. But now I would like to give word to a member of the Latvian Youth Delegation to the United Nations, Ms. Anita Bīķe, who has a question for the panelists. Anita, the floor is yours.
Thank you. I'm Anita Bīķe, and I'm a master's student of international security, gender equality advisor to Canada. Thank you for the very interesting discussion today. I would like to address any of the candidates who like this would be something important to them if elected in the ILC. How do we assure that the future of international law safekeeps everyone around the globe as effectively as it can, including marginalized groups, mostly gender and racial groups? For example, would you see legal language as an effective tool for assuring intersectionality? When it comes to, for example, unpaid domestic labor or even the environment, which is a challenge that we face unequally, but the environment.
Anna has disappeared, I believe, at least from my screen. But I believe the essence of Anna is back. But the essence of the question was, I believe, the inclusion of intersectionality of gender and race in the future of international law. If any of the panelists would like to kick this off with an answer. Any takers?
Well, I will if no one has. I mean, I'm understandably reluctant because I have very strong views on this, nominated as I am in a region which has nominated 14 candidates and I'm the only woman. And the ILC records on inclusion is appalling. And it's very difficult to say. There's no national system which would regard this as acceptable today. I cannot think of any. And I cannot think how anybody can claim to be democratic, to take the views of all that matter, because as I keep repeating, it's a subsidiary organ of the United Nations. It's a subsidiary organ of the General Assembly. It is paid for by the UN, it's paid for by taxpayers. At a minimum, it has an obligation to be inclusive and democratic. And only then and only that way can it have any degree of legitimacy in terms of decisions that come out of it. I leave it to others to say how we can take this forward. As I said, you only have to log on to the ILC website to see that this is an appalling record, which no institution, no government, no democratic, not even in a democratic state.
I don't know what happened there, but thank you, Professor. Okay, some technical difficulties. I see, Ambassador, you have your microphone turned on.
Thank you, Ms. Nipche. I would subscribe also to what Professor Okawa said. I think it's regrettable when it comes to Latin America and the Caribbean, for instance, none of the candidates are women. The fact is that, of course, there are rules when it comes to the presentation to the nomination of candidates. So I think when it comes to that, I think it is both the responsibility of the states, and it is also the responsibility, perhaps, of the Secretariat to encourage, as it has done in the past, but perhaps more strongly, the nomination of candidate women. I think also the Commission itself can do a lot of things. I don't know if necessarily that needs to go in the direction of addressing that issue as a topic, but perhaps making sure that every time it addresses an issue, it also takes into consideration what is the impact and what are the views of minority and other groups, because women are not a minority. So I think that is something, and there is a lot to build upon. There are already lots of literature with the feminist perspectives on international law in the different areas. So the work is there. It's just we need to use it more.
Yes. I was interrupted. I have no idea what happened. I was told I'm being recorded and I should leave the meeting.
Leave the meeting? Oh, no, terribly sorry. There has been a technical issue then. If you wish to continue your point, you may.
No, that's fine. I don't think what I was saying was very controversial. The facts of the others speak for themselves. I don't know. No. So that's all I was making the point.
Yes, Your Excellency, the homework for everybody is to log on to the ILC's website, as you said. And now I see, Dr. Ridings, you have your microphone turned on as well.
Yes, and I will just be very brief on this. The The International Law Commission gains its legitimacy from its ability to represent different geographical areas and the legal systems of the world. But it also needs to represent the people of the world, and that includes women. And it also includes marginalized groups and others. Women and other minorities have a significant stake in the international law and in the rule of law. We've already seen how COVID disproportionately affects women, and as do the effects of climate change. So, and I keep, and this is something which I keep referring back to, is the words of Ruth Bader Ginsburg, who said that women belong where decisions are made. And when decisions are made in the ILC which affect women, then women should be there. But also, and this speaks to the future, women also need to be prepared to take up leadership positions and to be role models to others. And I think this is something which is really important. And it's essential that women actually take up the responsibility. So for all the young women in the audience here, I would encourage you all to take up leadership roles, to mentor other people and other women. And in that way, the situation in the International Law Commission will improve in the future. And let's hope it does. Thank you.
Yes, I see Dr. Poperinskis has a remark as well.
As well, in complete agreement with what has been said, and I think it's probably key to reflect on things that can be done by the ILC and things that can be done in relation to the ILC. I think that gender diversity is a consideration already taken into account in selection of special rapporteurs. We have the first female chair of the drafting committee, Patricia Galvao-Teles. I think that is something that could be taken into account in thinking about research assistants, of course, including other considerations like regional representation, as well as plainly engaging with authorities that one relies upon in footnotes. And I think, and then there's a question about things to be done in relation to international law. Now, one of the things that I'm interested in is comparative international dispute settlement law. And to the extent that that is any guidance, things will change if they are prescribed so in binding rules, not otherwise. So we have a gender diverse international criminal court and, depending on the year, European Court of Human Rights, because these are things that are provided explicitly in rules and procedures. So to the extent that that is the direction, I think that that is where resources should be focused. Perhaps somewhat cynically, I don't think that naming and shaming changes state conduct in this sphere. Hard binding rules are needed for that. And of course, International Law Commission is a wonderful institution because of that. And I think I must say that I really am completely in agreement about the point about role models. And as Ms. Knipse will know, this is something where Latvia is not in a bad place at all, with a female director of European Commission, Assistant Secretary General of UN, all the imaginable human rights institutions. So it's a privilege to be in such an august company. Thank you.
Yes, Professor Asada.
Thank you very much. Almost all I had to say has been already said by other panelists, but it's important to have as many as different opinions and also variety of opinions reflected in the ILC or other international fora. I think the Secretary General of the United Nations has adopted a policy of hiring more women, and I've heard that the exception, if some organs exceptionally hire male, then they have to explain why. So this is the policy that the United Nations Secretariat has been adopting. But in the case of ILC, unfortunately, this is an election, and before election, there is a nomination. And looking at a list of candidates, as Professor Oko said, there's only one woman from Africa, and there's only one female from Asia Pacific, and there's only one candidate from East European countries, and Latin America there's none, and there are several from real countries. So I think in terms of composition of ILC, I think what is just what should be done is perhaps what the states should do in terms of nominating people for the election. Thank you.
Thank you to all the panelists. Thank you, Anna, for your question. And seeing as we have gone over time quite a bit, and some of our panelists are not in the most favorable of time zones, I would like to now move to closing remarks and thank all of you for your incredible participation today, leading by example to the new generation of not only lawyers or law students, but also young people looking to change the world, as naive as that might sound, but also just changing the legal framework and way we see the world through it. So if you have any comments or remarks, go ahead at this time, but I would now like to thank you sincerely for the time you have allocated us for this productive and interesting discussion, and best of luck to you all in the upcoming elections.
Thank you very much, Ms. Kanupse. I should say that 30 years ago, I was the young student attending the International Law Commission as on the International Law Seminar, watching with amazement as the commissioners debated. I should add, there were 34 men then, and in the 30 years, not much has changed. So it would be interesting, but perhaps it's a conversation that will be had elsewhere. If there's to be progress, I think the fact that there hasn't been any in 30 years is a bit concerning. Most national systems have changed way out of recognition in terms of questions of gender parity, inclusivity. The conversation is very different. I think the International Law Commission ought to be a lot further than that. And I know Dr. Ridings mentioned the question of being role models, supporting younger women and seeing themselves as possibly also being in the positions we are. That's really all very true. But I noticed when I considered being a candidate that the barriers for women start much earlier. The statute itself requires you to have not just a question of intellect and be a jury consult in international law, but a lot of practical experience in matters of international law. And they are not women in any of those positions. If you look at litigation before the International Court, before ICSID, before these tribunals, questions of representation start much earlier. And that means for most women, they just feel they don't meet the bar. So the conversation has to continue and just see how we can include women at all levels of decision making so that they can put themselves forward when opportunities like this come up.
Yes, thank you. If there are no further remarks, many more discussions to be had. And again, best of luck to you all. Oh, I'm sorry. Oh, Dr. Ridings.
I would just simply like to end by on behalf of everyone, all the panelists, by thanking you, Ms. Knipscher, for your moderation, and also thanking the Latvian mission and also the Youth Delegate Program of Latvia for putting on this panel. It's been a pleasure to hear the very articulate contributions from my fellow panelists, and to your questions were very much spot on and very much appreciated. So thank you on behalf of everyone for putting on this panel.
Thank you so much, and I hope this wasn't too straining in terms of the time zone. We really need a solution for this. So thank you, everyone, and again, best of luck.